our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property. It'll be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody. Welcome to the show. Today, we're talking about using land trust in a wrap transaction. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, Facebook, and X, formerly known as Twitter. On all of those, you can find us at the handle @InRem Podcast. That's @InRem Podcast. Also, we'd love it if you'd go and download an audio version of the podcast. You can find it on Apple Podcasts or Spotify or any of the other major podcast platforms. Go there, download, leave us a review. We'd love that and appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is basically answering the question, what is a security agreement and when is it used? So a security agreement is creates a lien against personal property. So in the real estate realm, we talk about mortgages and deeds of trust. When we talk about personal property, you can create liens against personal property, but they're generally created through the use of a security agreement. So it's basically your mortgage or deed of trust, but for personal property. Common examples of where you would want to use a security agreement would be if you're buying and selling a business on terms. And so you're going to carry a portion of the purchase price for the business. You would normally want a security agreement executed, giving you a lien against all of the assets of the business. So a lien against the bank account, accounts receivable, furniture, fixtures, equipment, inventory, all of that. It gives you a lien, a blanket lien against all of that. Another common example is you want to take a lien against a vehicle or this is one that's more related to real estate, a manufactured or mobile home that is not affixed to the real estate. So that would still be personal property. And so you want to lien against that. And the way you would take the lien or the agreement to provide the lien would be through a security agreement. Now, once you have the security agreement executed, you have to then perfect your lien. So the security agreement in and of itself is not the lien. It doesn't perfect the lien. Just like a mortgage or deed of trust, it creates the lien, but the lien is perfected by the recording of the document. So with the security agreement, additional steps have to be done in order to perfect the lien. One common example is for vehicles, or even a manufacturer mobile home that's not affixed to the real estate, and you have a security agreement giving you a lien against it. The way you perfect the lien in that circumstance is you actually take possession of the title and you list yourself on the title as a lender. And then that way you perfected your lien because you hold the title. The title is not released until you're paid off. Another way and a more common way to basically perfect your lien through a security agreement is you go into the Secretary of State's office for whatever state the personal property is located, and you you file with the Secretary of State a UCC-1 financing statement. Now that document does not require anybody's signatures. It just has to be filled out. But in order for you to file it, you have to have the authority granted by the security agreement. So the security agreement is going to have a clause or provision in there basically saying, okay, the creditor has a right to go and file these UCCs And by filing them, then it creates a lien against the whatever personal property is. So, for example, if you're buying and selling a business or an ownership of interest in a business, it would be very important for you to figure out what debts and obligations are out there, for you to go to the Secretary of State where this business operates, or the states where the business operates, and do a UCC1 search. There's also companies that will allow you to do like a nationwide UCC1 search, but you go in and you search to make sure there's no lender out there that you're unaware of. Nobody's claiming a lien or anything against the business. The security agreement, though, is the underlying document that gives the creditor the right to have that UCC1 financing statement filed to create that lien. So a security agreement is basically the same as a mortgage or deed of trust, but for personal property. And you would use that to create a lien against personal property to secure some type of performance or repayment of a debt or obligation.
All right. Thank you for the legal update, Sean. With that, let's go into a couple of announcements. Join us this afternoon. Every Tuesday afternoon, we engage and do what we call the Collective, or the Creative Finance Collective. That is every Tuesday at 2 p.m. Arizona time. So what is the Collective, you ask? That is a group, a membership of professionals that focus in the space of creative finance, mainly attorneys, and we get together from a variety of different states, and we talk about what it is that we do, which is focus on creative finance, how states are passing laws or regulating creative financing, what lawyers are seeing in different states, how they're structuring their contracts in order to better deal with creative financing issues. But one of the benefits that you have as a viewer is we make ourselves available for the entirety of an hour to answer questions that you might have relating to creative finance. So if you've run into a specific problem, or maybe you're just approaching creative finance as kind of an investment type opportunity, and you're looking at, well, what does this even look like? What do lawyers have to say about this? You know, I've heard what the guru on YouTube might say about this, but what are lawyers saying about this? And what are some of the pitfalls and issues that I face in that regard? This is just an excellent opportunity for you to come, be a part of the discussion, and talk and hear us talk through that. So we're on for an hour or until we stop getting questions. So it's important for you to engage. Again, every Tuesday at 2:00 p.m. Arizona time. And you can find that on YouTube, Facebook, or X. So make sure to join us. Look forward to seeing you there. Also, if you have a question today for Sean or I or our guest with regards to our topic at hand, and again, we're talking about wrap transactions and land trust today. If you have a question about that, make sure to post it in the chat. And if you think about a question just a few minutes into the episode or halfway through, make sure to post it in the chat. We're going to review that in the final 15 minutes of the episode. If we have questions, we will get to them then. With that, let's go ahead and get into our topic today. Again, we're talking about using land trust in the wrap transaction. And in previous episodes, we've talked about wrap transactions. In previous episodes, we've devoted entire episodes just to the land trust itself. Today, we want to talk about using the land trust in the wrap transaction, what that looks like, and what to expect, and some of the benefits in that. And with us to discuss that topic, we have two lawyers here with us to discuss it. First is Alan Ceshker. Alan, thanks so much for joining us.
You bet. Appreciate it. Thank y'all for having me.
Yeah, I know we've had you on before. Some of our guests would be familiar with her, but with you, why don't you give us a little bit of background about you, your law practice, and how you got into doing what you do?
Good deal. Yeah, so I'm a Texas-based attorney, and we have a title effort. We're a title office and close all transactions, but obviously focus on the creative finance stuff. And been doing mortgage wrap transactions since before the recession, but really got deeply involved in them during the 07-08 recession. And when we came out of that recession, we kind of just stayed in the little niche market. And so it's what we do. It's what we always say, live, eat, and breathe. And so we've got offices around Texas and close primarily in Texas only. And really, enjoy talking with you all, and all the folks who are chewing some of the same dirt. So it's kind of fun.
Now, Alan, I know you also run and created the Rap University, which I know not only Sean, but some of our listeners have taken advantage of and been a part of and find huge value. And tell us a little bit and our listeners about Rap University.
Yeah, so Rap University was created from, 20 years of closing mortgage wraps and seeing what needs to be done, the questions, et cetera. And so it's a short little 4-hour program where we go from before contracting to post contracting and everything in between. It's even a 4-hour accredited course here in Texas. A lot of the information is applicable around the nation. And so it's always growing too. So we just had Rap University in San Antonio last Saturday, and that version is substantially different than the April Rap University in Houston. And so we have it about every 2 months in the different 4 big cities of Texas.
Awesome. Also with us to discuss our topic today is another attorney out of Texas, Mark Sessums. Mark, thanks so much for joining us.
Thank you for having me.
Yeah, so we appreciate you being with us. Tell our listeners a little bit about you, your law practice, and how you got involved doing what you're doing.
Yeah, I've basically, so I do real estate and real estate litigation for the most part. I do also get out into some probate and some estate stuff just from necessity, which gives me kind of a tie into what we're going to be talking about today. How did I get here? God, that is a good question. I was a real estate broker for about 20 years or so. Decided to go to law school. After that, it only made sense to continue on with real estate law. We've been doing that for quite some time.
Yeah, well, we appreciate again you being here. So let's get into this, and I'm going to pose some of these questions, Alan and Mark, to both of you here, and let you kind of decide how you want to slice and dice this. But I think it's important as we get into the topic just to lay some real basic groundwork and give a few definitions for the audience. When we say land trust, what are we talking about? What is a land trust?
So I'll let Mark jump in. I'll just give my 2 cents in terms of it's not a trust, an estate planning trust. It's not for the liability protection aspect. It's for the creative finance and to create some anonymity. But Mark, I'll let you talk to some more of the law and statute side of things.
Sure. What is a land trust? So a trust is no different than any other trust. It's a statutory, it's an instrument that what you're doing is you're placing a property in trust with another person. Depending on how that can be done, sometimes that can have legal protections for it, as far as, getting sued. Other times you can use it in estate planning. You can use it in all these different methods. And the whole idea and concept behind it in this situation is going to be the anonymity involved. Because a trust is not a filed document. It's not something that gets filed publicly, or at least in Texas. And it keeps things private. And you can use that to pass property from one person to another. You can use that to maintain an estate and make distributions to the beneficiaries. And that's kind of what we've decided here and what we're doing here.
Now, Alan and Mark, in some states, Sean and I come at this from the states of Arizona and Wisconsin. I know you guys are in Texas. Every state's going to be a little bit different in how they treat land trust. Some of them are, common law based. Others have a statutory scheme built in for land trust. I know Florida is a state like that. They've got a pretty detailed statute on that. Is Texas a statutory land trust state, or do they just rely on common law as it is?
Well, there's some components of the code that lay out the guidelines for trust in general, but it doesn't necessarily go into this is how you do a land trust.
So if I understand, and this is how it is in Arizona and Wisconsin, is we have a trust code or trust act, And it basically says, this is what you do to create a trust, but it doesn't break it down of land trust, estate planning trust, et cetera, et cetera. It just says, here's how you create a revocable trust. Here's how you create an irrevocable trust. And it lays out the different components. And then you're off to the races to figure out the type of trust you want to form, et cetera. Is that kind of the same for Texas?
Absolutely. And that's going to be held in between the property code and the Texas estate code. So between those two, it lays out the guidelines.
Yeah, but there's not a special, hey, if you want to hold real estate and it's only for real estate, here's a land trust and here's the special provisions. There's nothing like that in Texas.
No.
Correct.
Yeah, that's how we are in both Arizona and Wisconsin.
So you mentioned one of the primary reasons for using a land trust happens to be anonymity. In that vein, are there requirements on how a name is determined for the trust and given, or is that just purely up to the creators of the trust?
Purely up to the creators.
And I on our creative finance transactions, I default over to the address, 123 Main Street, revocable trust.
And there are slight exceptions to that, and that is if it's a revocable trust versus irrevocable trust, it should have the word revocable.
Yeah.
Oh, okay. So it has to state whether or not it's revocable or irrevocable. So let's jump into that. What's the difference? Alan said that for the creative, it's 123 Main Street revocable trust. But what if somebody said, well, I want irrevocable? What would that even mean? And what's the difference? What are the advantages, disadvantages?
So let me jump in terms of what we do with the creative financing, and then I'll defer to Mr. Sessums, who knows the law substantially better than me. We're needing that revocable trust over there with our creative financing because it allows us to get the tax exemption for the property tax. If you don't have it, if it's not revocable, you can't get that homestead exemption out of the CAD, out of the Central Appraisal District. And so that's why we're doing that. And then on the real law stuff, I'll defer to Mr. Mark.
Well, at its most basic level, it's exactly as it sounds. If it's an irrevocable trust, that property's stuck in there, and that trustee and that beneficiary, they are set. And there may be some language in there that allows for a successor trustee or beneficiary, but that trust does not go anywhere. And the creator of that trust, also known as the settler, they can't change it. Once that is put into place, it's in place. You can't say, no, I changed my mind, take the property out. Now, the benefits of that, in the trust world, you can do all sorts of crafty stuff there. You can do generation skipping trust for taxation purposes. You can do charitable remain trust. You can do tons of different things that affect taxation and how things pass. You can control things, beyond your death, which, by the way, any revocable trust becomes irrevocable upon the death of the settler. But what you can't do for these creative finance deals is you can't really ever go and just sell that property if you're the beneficiary, because you're not in control.
Mm. And my understanding is an irrevocable trust, you actually have to have a tax ID number, as opposed to a revocable trust. You just use the settler or grantor's social security number.
You should.
Okay. Now, I just used the two legal terms there. I said settler and grantor, and we haven't defined those, so we probably should. Who is the settler? Who is the grantor? Are they different? What does that mean?
Well, there's actually three words we can use: settler, grantor, trustor. We prefer settler because it just keeps things a little clear, because then you start talking about beneficiaries and trustees, and the words sound a little bit different. But you can use any of the three, and they pretty much mean the same thing, because you are the person creating the trust. You are the one stating the terms of the initial trust. You are settling the situation, settling the trust. That is the difference between those three words, and they are all interchangeable.
So go ahead, Alan.
Well, so I think we're going to find a little ping pong game here that we're going to have. I'll talk about what we're doing over there in the creative finance side of things, and in the title closing side of things. So our settler is always going to be the buyer in the transaction, and the reason for that is because that settler retains some type of control over what happens with the trust, and so we want the buyer to have that control. And then in terms of the beneficiary, that's the owner of the trust, and so we obviously want our buyer to be that owner. And I'll hold on talking about trustee until you get to it if you want.
So, and I think this is important to clarify. So, if what Alan is saying is correct, the person that creates the trust, who we're calling the settler or the grantor, the trustor, if that trust is revocable, then like what's their limits, or are there any limits on their ability to go and change that trust at any time?
Well, there isn't. So let's think about this in the most common usage of it, which is actually not a land trust, but it's an estate planning. I place all my property into a revocable trust. I maintain possession of it, control of it, everything else. But my subsequent beneficiaries that I put in this trust, I put my kids. And when I pass away, all that property automatically transfers to my kids, and you can avoid probate that, like with that, or at least in the state of Texas. So it's a method of transferring those assets. But during my lifetime, because I do want that control, I have to have a revocable trust. Now, as that applies over in the creative financing, as the buyer, you don't want someone else to have the ability to revoke your trust if you're buying and putting property.
So, and I've seen this strategy proposed by the gurus out there on land trusts, and I just cringe. So if I hear what you're saying is, it would be a very bad idea for the seller to create the trust, to be the settler, and to then put the property in the trust prior to the transaction. Is that?
I'm going to go with bad being a good word to use there.
Yeah.
Okay. And
that's a pretty good word.
Yeah. And if I'm hearing you correct, that would mean because the post-closing, the seller could get upset at the buyer, amend the trust, remove the buyer as any involvement in the trust, and then just go and sell the property, right?
Well, and we if you've practiced in this arena long enough, you've seen a seller get angry, either have seller's remorse, or maybe weren't educated appropriately on the structure of the transaction, whatever the reason. And so my term is I say the seller is going to pull the pin and hug their enemy. And so they'll call the bank and say, hey, I've sold my property, you need to foreclose, and things of that nature. Leaving that seller as the settler lets them go and revoke the trust, for example, and start monkeying around with things. So we want to take that power from them.
So talk to me about how the trust itself is formed. You mentioned anonymity, and you mentioned there's some privacy to this process. But when I conceive and I hear the idea of forming something, I automatically think, my non-lawyer self automatically thinks, well, I got to go to in Arizona, the Arizona Corporation Commission to form an LLC. I got to go there to form a corporation. Maybe in other states, it's the Arizona Secretary of State's website. Is there not some department of trust that I have to go to within a respective state to establish this trust? How is it formed and given legal respect, credibility, and recognition?
So Mark, you go first on the legal side, then I'll talk about what we do side.
Well, no is the simple answer. No, you don't have to go to anybody. You draft up that document, you place the property in it. Now, if you ever go to a litigation situation, the first thing they're going to want is the document, and it better be signed, and it better be proper, and it better be right. But it's no different than, say, a construction contract or any other type of contract. It's a contractual obligation between the settler, the beneficiary, and the trustee.
So what we're doing on the creative side is, and that, you see the forms out there that the gurus have floating around. And so a lot of times the parties without legal representation will go and try to, what I call, poof these things into existence. And that's a bit dangerous. And so what we have is that settler creating the trust, but it's the attorney obviously drafting up that declaration of trust. And then the statute actually provides for if title office or some other entity wants to see evidence of that trust, they don't actually go straight to that declaration of trust. Initially, there's a statute that allows for a certification of trust to be provided, and that keeps the beneficiary still out of the equation. You're not required to disclose that beneficiary. The trustee and the settler are disclosed in that certification of trust, and that's what we'll utilize when needed for closing or other needs.
Yeah. So the certificate or certification of trust, that's just like a condensed version of the trust. Would that be accurate? Kind of lays out who can act on behalf of the trust. I mean, it's much shorter document, right?
Well, yeah, a lot of times those are just a one pager. It says trust was created this date. Trustee is this person. That's about it. I mean, they are very, very slim, and yes, it's still in existence.
And I will tell you that the title office is supposed to advance once they receive that. However, sometimes it's a bit of a struggle. Education has to occur. And then if we keep running into problems, we defer to their incorrect request of the actual trust document. We'll provide that over to just so we can advance.
Yeah. Well, I've noticed even just on my personal experience that, each, whether it be a title office, bank, other financial institution, some of them are good with the certificate of trust. And in Arizona, we have a very similar statute, which says you're supposed to accept it. But others say, nope, we want the full trust. And then, you either do business with them or not. Is that kind of your guys' same experience?
Yeah, exactly the same.
What about things like taxes? Another thing somebody's thinking of, or if you're putting your investor's hat on, you're thinking, okay, well, I don't have to file this like I do with an LLC. I can keep some anonymity. This is starting to sound nice. When it comes to taxes, does a land trust, or I guess just a revocable living trust, have to file a separate tax return and gain that separate tax ID, or is it just kind of flow through to the individuals?
I'm going to give you the attorney answer here, and maybe it's all what you're trying to accomplish. You can have this just pass through and do it all under your own social security number. But sometimes you want to hold LLCs or hold different stuff within the trust, and you want each of them to file its own tax return. So in that situation, you would have to do it a different way. But for the most part, in the situations that we're talking about here, these are just going to pass through.
Yeah, and I can tell you the intent of our trust documents is that pass through. We're a lot of not requiring the EIN, and then additionally we embed in our trust document the ability for upon the sale of the property, the funds to be directed over to the beneficiary itself, avoiding the need for a bank account, et cetera, because I call it not a real trust. It is a real trust, but it's not for like I said earlier, it's not for the purposes of estate planning, liability protection, and things of that nature. It's for the handling of that creative finance transaction, that land trust.
Interesting. So
it's not going to be like a 152-page trust document that you quite often see in plan.
Right.
Oh, so it's going to be much smaller with provisions that are more specific to owning real estate as opposed to a general estate planning trust.
Yep.
Absolutely.
And so you're trying to avoid having a bank account. You are putting provisions either in the trust or in, say, a lease where the trust owns property. Where are the provisions going that basically says, hey, anything that is supposed to be paid to or for the benefit of the trust, it needs to go to the beneficiary?
So we were running into problems because a title, a title closing office is required to issue funds to the vested owner. The trust is the vested owner, and so especially if there was no attorney assistance, there was no appropriation for this. There's no bank account. We're issuing checks to the trustee for the trust, and then they're yelling at us saying, "Hey, we don't have a bank account." And so to solve the problem, I've embedded in the trust declaration that title office is authorized to issue payment directly over to beneficiary, and it's underlined and in bold, so we can hopefully help the underwriter see and receive that. But it's going to ultimately be the underwriter's decision on that, and I can see them going south on us. So every once in a while, you have to go out there and create an account just to process the funds.
Well, so what would that look like to open a bank account, right? So I have this trust. Okay, great. I have a land trust, but how do I collect funds? How do I use it? What would I do if I wanted to go open a bank account with this trust? Where would what do I do? What do I provide? Do I need a tax ID number for the trust? How does that work to get a bank account open?
Actually, no, you just walk right in. If you are a sole beneficiary of it, and there's no question as to that, most banks will open it with your same social security number, never the need for an EIN. If you did just want to get crafty, you can get an EIN with your trust just so it has its own EIN if you're ever issuing any type of statements. And then the IRS will just view that as a disregarded entity.
So, Alan, on taking it a step further from closing to actually owning the property and operating the property in the name of this trust. Let's say I'm going to take title in a land trust, and it's going to be a buy and hold property, a long-term hold, and I'm going to put tenants in this property. And I go to prepare the lease. Well, the property is owned by the trust. Myself, or say my LLC, is the beneficiary of the trust. Who signs the lease?
So the trustee is going to sign the lease on behalf of the trust. And you mentioned LLC for beneficiary. I always advise and encourage folks to use their LLC as a beneficiary, and that pulls back in that liability protection. But it's the trustee. So, for example, the deed goes to the trustee, individual name as trustee for XYZ Trust. They're the grantor on the deed of trust document. You can actually enter into a contract with just the trust name versus trustee as trustee for the trust. But the trust is the legal party in the lease transaction.
All right. So the trust has to be on that lease. You can't just put in your LLC that's the beneficiary as being even though you could put into the lease that the payments are made to the LLC as opposed to the trust.
Yeah, absolutely. Just like a management company or what have you, there could be agreements between the trust and even the beneficiary, allowing beneficiary to act in that management company type role for the trust.
Now, mind you, your signature line is going to get quite long here when you start embedding LLC in trust, all that, because it's going to say something like the Mark Sessums as trustee of the Mark Sessums Revocable Trust. as managing member of LLC. So be cautious of that, because that will bite you.
Mm.
Well, and along that same vein, a lot of times, since, and I hate using the terminology, but it's just easy to conceptualize, since it's not a real trust, the title insurance folks are wanting the beneficiaries to roll in and sign off also. And so you may lose some of that anonymity when that occurs, but they want that beneficiary liability to be taken care of on the closings.
Now, we've used the term trustee, but I don't know that we really dived into who is the trustee, how are they determined, what do they do? So who is the trustee in all of this?
I can tell you on the creative side, and then I'll kick it back over to Mark on the law side. We've got two choices. The buyer acts simultaneously as trustee and beneficiary. I will say initially, we want the seller in there as a trustee to get closer to Garn St. Germain compliance. I say closer because we're never in full compliance because of a couple of reasons. But ultimately, at the end of the day, the buyer is a trustee either initially or secondarily. Now, sometimes folks want me to act as trustee, and I don't like that because it does create a bit of liability. Trustee is going to be the party served and answering if there's a lawsuit, for example. And I don't like being invited to lawsuits unless I'm actually an invitee and have an interest in it. So I try not to be that trustee, but a lot of times we have to default over there. In terms of who can be a trustee, well, Mark can correct me. I think entity can be a trustee. LLC can be a trustee.
Right. So trustee is defined as a person, and then when you jump down in the code and it looks at how a person is defined, it says a individual, an entity, an LLC, a partnership, and just lists pretty much everything. So yes, that is possible.
So I could go create a trust, and I don't have to be the trustee of the trust. I can just say, hey, seller, be the trustee, or Alan or Mark or Andy. It doesn't really matter. I determine it when I create the trust.
You might want to check with the person that you're naming before that, but yes.
Yeah. And I use the analogy of, or the example of a joint venture agreement. A joint venture is created by that document, and so magically it poofs into existence. Same thing with the trust. That joint venture agreement or that declaration of trust is how those are created.
Now, what if I, appoint Alan and I realized later it was a major mistake and he's doing a terrible job as trustee? Am I stuck with him forever?
No. But the trust will either have removal methods or subsequent trustees listed, or you're going to have to go to the courts. If you go to the courts, it's going to get a little tricky, and pretty much everything that we've been trying to work towards will be knocked down here.
I'm not certain what I was doing wrong in regard to the trustee role, but in my trust documents, the beneficiaries do have that right. If trustee passes away or is gone, then beneficiary does come in and create what's it called? Creates a new trustee for the document.
Yeah. No, of course I was saying it facetiously. I'm sure you would do a bang up job, but in any event, do I have to serve, like, let's say Alan's serving as trustee. I'm like, just not working out. I'm going to, have him, no longer serve as trustee. What do I have to, I have to amend the trust, but then what kind of notice do I give to Alan? Do I just be like, call him up, be like, hey, you're out? Or do I, have to actually serve him? Do I have to deliver something, to him? What does that look like?
I would go ahead and deliver something to him. You don't want people acting on apparent authority. And if they think that they have the authority to do that, you don't want them going out and taking those actions. So I would definitely give him some type of document revoking his trustee duties and stating that there's the new trustee, whether that's done in a revocation or just simply in the appointment. It's different ways of doing it, but yes, always with notice.
So that designation of new trustee, that document could be it. But a lot of times what we want is an actual resignation from the trustee themselves. That way there's complete understanding and evidence.
Now,
will the terms of the trust typically control how notice is given in that circumstance?
On mine, yes.
Yeah, it will, and in the event that it doesn't, then it falls back to the code.
Now, back to Alan's, in my view, brilliant idea to name the seller as the initial trustee, because you're trying to create a certain level of anonymity, right? I mean, the whole purpose of a land trust is to create anonymity. Well, there's no anonymity created if it goes from the seller to Sean St. Clair as trustee of the 123 Main Street, and I'm the one buying it, right? It's like, oh, Sean's buying it. Like, that doesn't do me any good. I want to be behind the scenes. I don't want to be known. But if I make the seller as the trustee, then it would go from the seller to the seller as trustee. So anyone looking at it would potentially be like, oh, they're just, doing some estate planning or whatnot. And you have really good anonymity. Doesn't quite work in Arizona, but we're not even going to go down there for various reasons. But the seller is on there, and it looks like they're just conveying it to the trust. But in behind the scenes, I'm the one that created the trust. I can remove the seller as trustee. The seller can resign as trustee. But, when you talk about your apparent authority issue, what can I do to protect myself when I remove the seller as trustee? There's nothing that is, it's an amendment to the trust that I delivered to the seller, or the seller signs a resignation. But how do I put the world on notice that, hey, this seller can no longer act on behalf of this trust?
You don't.
You don't.
So that's a risk.
It's a risk. And something you mentioned there about naming the trust that way and having the seller as the trustee, I don't think you're going to have a real happy seller in doing that, just because most of these sellers, they're trying to get rid of a piece of property. They want their name off of something.
Well, let's say the seller's willing to do it that way for various reasons. They may be. Can you record like a notice of like if your LLC is say a Wyoming or Delaware LLC, so an anonymous LLC, and they're the beneficiary, can you record like some form of notice of beneficial interest or notice of some memorandum, so at least you put something on record that, hey, if we're going to sell this, we better check with this LLC for future closings?
Mark, you know of anything that can be filed? I mean, my answer is yes, because I have, to prevent against fraud, on those properties that are paid off. Sometimes there's folks going and trying to sell property that's not theirs. I have what I call a BS lien, business services lien is what I term that. But anything can be recorded. But Mark, is there anything specific in the code that you know of that would allow for that?
Well, other than just your property code and your government code, which controls real property records, anything that shows an interest in real property can be recorded. You could craft something like Alan's talked about. You can do a memorandum of interest. You can do, whatever you'd like. You can put it in there.
Well, and if we take that even a step further, we could, in theory, because that's my concern, is that this is all good and well, but what happens when the seller goes and creates a fraudulent trust, giving them all powers, shows that to a title company, and they sell the property out from under the buyer because they've done this land trust style transaction. Could you record, without naming who the successor trustees are, could you record a notice of resignation of trustee and just basically have it notarized? So the resignation would be, or the seller would sign it, notarize it as part of the closing, which basically says notice is hereby given that seller hereby resigns as trustee of this trust and no longer has any power or authority to act on behalf of the trust, and just record that.
Well, so I think you're probably starting to work against yourself here.
Okay.
And the reason is we're doing this to create, in these land trust situations, especially with the wraps, we're doing this to create more of a don't ask, don't tell situation to where people don't question things. And if you start putting things out in public record, your taxing authority is going to pick up on it, and different places are going to see this, and you might be drawing attention to yourself that you really don't want. Preventing fraud, well, we could probably go down different avenues of doing that. I could think of a few. You could, record a lien back to your own LLC as a secondary deed of trust or something like that, to where a title company would have to call you. But so there's methods of doing it, but at the end of the day, we can't prevent every type of fraud. There's people right now that go out there and just create bogus deeds and file them in real property record just to see if they can do it and get away with it.
Now, one of the logistic issues with title is that exam, that exam department, that examiner that's looking at that and sees this notice that doesn't affect any type of encumbrance or cloud on the title, it may not make it over into the title commitment, and so therefore may not stop that transaction. I do like Mark's suggestion of maybe a actual deed of trust lien provided to the trustee as the beneficiary. Not an effective lien. There's a merger of title, and there's all different types of legal issues. However, functionally, that examiner is going to go, okay, I need a release of this. Mm-hmm. So that would make it through.
Talk to us about liability. I think this is a common cause for confusion, but corporations, limited liability companies, they have this thing called the corporate veil, and the members, the shareholders of the corporation, as the case may be, are not liable for the debts and obligations of the company. That's how the corporate veil works. Is the same true with the trust?
So I'll answer first. Mine provides no liability protection at all. It's not for estate planning. It's not for that purpose. And so there's zero. And I'll let Mark talk about the actual protections.
Yeah, he's absolutely right. Any irrevocable trust has no protection. And the whole thought concept behind that is, if I can put my money in there and hide it from my creditors and then just revoke it later and have full access to it, we're not allowing that in law. However, if I put all my money in there and I no longer have any control over it, and it's not my money, and the beneficiaries are simply my children or somebody else, sure, you can't go after my kids' money that is in their trust, but I can't do anything with that anymore. I've lost my control. And it's that control that is what is really limiting us to whether or not we have liability.
If the assets placed over there before any type of claim exists, it can't be after a claim exists. That'd be a fraudulent transfer and no protection.
Mm-hmm. Right. So let's talk about buying property in a land trust and what this looks like from a liabilities perspective, using maybe a hypothetical. I go and I decide, okay, I'm going to buy a property, buy it on a wrap maybe, and the buyer is going to be my trust that I create, the 123 Main Street Revocable Trust. I form this trust. I'm the settler or the creator of the trust. I name my LLC as the beneficiary, the whole thing. I then buy the property into the name of the trust. So the property moves over into the trust. And 2 weeks later, God forbid, I'm driving and I blow a stop sign. Pedestrian is there. I hit him, seriously injure or kill them. Multi-million-dollar personal injury claim against me. Does that property then have exposure to that?
As a revocable trust, yes. You're beneficiary, right?
Or my LLC is the beneficiary, but I'm the one that created it.
Yeah, it's not going to protect from liability with that entity back in there. That does provide you with the same liability protection that an entity provides. The entity's liable up to the assets of the entity, assuming there's not any type of problem with the entity and you pierce that veil.
All right. I understand we do have a question that was posted to us in the comments. Maya, why don't you post that question for us? All right. So how does the wrap transaction and trust compare to having seller's name on the deed along with buyers of the property sold with owner finance?
That's funny. I was getting ready to say I've recently heard that question, but I recently heard that question because it was from that individual. So that methodology right there is fantastically dangerous, and I can't imagine any attorney ever advising to have both buyer and seller remain on a deed. It's going to allow seller to go out there and sell their interest in the property. It's going to bring all of seller's liabilities over to that property. It's just not something that's going to be advised. So the trust, even though seller might be the initial trustee, and so what you're looking at is seller selling individually over to seller as trustee of trust. It is a arm's length transaction, title insured, et cetera. A seller deeding a property from seller to seller and buyer is not advisable and never going to be used, at least not by me.
Now, let's talk about disposition. So we talked about buy and hold, entering into leases, but let's say I buy the property in a land trust. And I decide, I want to unload this property. Keep the wrap transaction in place, but sell to an end buyer who will be then responsible for performing under my original wrap transaction, and maybe pay some money to me, or I carry some terms. When you have it in a land trust, does that create any additional opportunities as far as conveyance of the real estate?
So yes is the answer. It gives you the opportunity of assigning the beneficiary interest as the complete transaction. I don't necessarily like those as much. Your title insurance isn't going to flow through. The usual structure is to have the trust get out of the middle if it's ending the wrap transaction. If it's not ending the wrap transaction, then that assignment is good. It does decrease your closing costs, and then there's going to be changes in the insurance policy. For example, hazard insurance. So your homeowner's insurance is going to change from the 123 Main Street Trust with individual A as beneficiary to 123 revocable trust with beneficiary B now being the insured, because the insurance provider is looking through the trust to the individual to determine rates. Conveyance of the benefit. I know I got lost there for a little bit, so sorry about that.
That's all right, Alan. We got you. Well, guys, we appreciate you being with us. Boy, the ins and outs of how to integrate a land trust with a wrap transaction are plentiful. A lot to go through. We could have another episode on it. Maybe we will. We appreciate you guys taking the time. While we're here, Alan and Mark, give our listeners an idea about how they can connect with you.
So I'm simple. If you can spell my last name, Ceshker. That's how you find me. There's benefits to a name that was made up when great granddad was coming through Ellis Island. And so if you want to take part in our RAP University or reach out or have closings in Texas, you just go to Ceshker.com for me. And then also gets us over to Mark as Mark acts as of counsel. But Mark, I'll let you take care of yourself.
Yeah, that was what I was going to say is if you can get hold of Alan, you can probably get hold of me. Otherwise, you're welcome to email me at mark, M-A-R-K, at mark dash, no, I'm giving you the wrong email. Mark, M-A-R-K, at Sessums, S-E-S-S-U-M-S, that's 4 S's like Sam, -law.com. So mark at sessumslaw.com. You can also call 512-297-6832.
All right, Alan and Mark, thanks so much for taking the time to be with us. It was really good information. Let's do it again soon sometime.
We appreciate that. Thanks very much. And I do agree that it's a big topic and probably can spend another hour on it.
All right. Will do. Thanks, guys. We'll see you next time.
All right. Thank y'all.
With that, everybody, that is our show. Thanks so much for joining us. Make sure to join us today, 2:00 p.m. for The Collective, and next week, every week at Tuesday at 10 a.m. For next week's show. We'll see you then.
Have a good day, everyone.